Good evening.
Good evening. Good evening.
Call the meeting to order. Ms. Ray, would you do a roll call, please?
The Honorable Linda J. Davis.
Present.
The Honorable Patty Portis Jones.
Present.
The Honorable Ulysses Smallwood is absent. The Honorable James Whitmore.
I'm present.
And the Attorney Rory Starkey.
Present.
You have a quorum.
Thank you. We are here tonight as the investigative committee to consider an ethics complaint filed by Mayor Mario Avery against Councilwoman Samantha Hudson. Is there a motion to approve tonight's agenda concerning ethics complaint number 2025-04, Avery versus Hudson?
So moved. Second.
All in favor, say aye.
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 Opposed? The motion carries. Before
Regular agenda is going to be a discussion of the ethics complaint number 2025-04, Avery versus Hudson.
Before discussion begins, I will explain how tonight's meeting will proceed as required by the Ethics Code. First, we will review the ethics complaint by having the clerk read it and its attachments into the public record. Second, as this public reading, if there are no questions or comments from the committee members regarding, I will entertain a motion to convene into executive session for the purpose of deliberation. Third, after executive session, we will come back into public session to take a vote. One, whether the investigative committee should subpoena more witnesses or documents in this matter, or two, whether the complainant should be forwarded to whether the complaint should be forwarded to the ethics board or a hearing, or whether the complaint should be dismissed. Madam Clerk, will you read the ethics complaint number 2025-04, including attachments, into the record?
The official ethics complaint filed pursuant to Section 2-35 Code of Ethics, City of Fairburn Code of Ordinances. Complainant Mario B. Avery, Mayor, City of Fairburn, Georgia. Respondent Councilwoman Samantha Hudson. Number one, the basis of complaint. This complaint is submitted in accordance with Section 2-35 Code of Ethics of the City of Fairburn Code of Ordinances. I allege that Councilwoman Samantha Hudson has committed multiple willful violations of Sections 2-35C, prohibited conduct, specifically Section 2-35C3, no city official shall disclose or otherwise use confidential information acquired by virtue of his or her official position for his or her or another person's private gain. Section 2-35C11, no city official shall make any disclosure of confidential information without the approval of the body on which the city official serves. Number two, summary of events. Notice of EEO complaint was on August the 6th, 2025. On Wednesday, August the 6th, 2025, Councilwoman Hudson was formally notified by letter copied to the entire City Council that City Clerk Brenda James had filed a written Equal Employment Opportunity EEO complaint with the Human Resources Director naming Ms. Hudson as a subject. The letter confirmed the complaint was proper and actionable under Section 2-50.6A of the city's Personnel Policy and Procedures Manual. Ms. Hudson was advised that retaliation, direct or indirect, against Ms. James was strictly prohibited under Sections 2-50.6B and could result in additional consequences, including formal council action or referral to ethics or legal authorities. She was explicitly instructed that because this is a pending personnel matter, any discussion must be conducted only in a duly convened executive session, not in a public meeting. Number 2, refusal to comply, August the 7th, 2025. In a rebuttal letter sent at 12:16 p.m. on August the 7th, 2025, Ms. Hudson wrote, "Let me be clear. I will not comply with any directives that unlawfully restrict my ability to perform my duties as an elected official. This statement is a clear rejection of the confidentiality directives issued on August the 6th. Number 3, legal clarification by City Attorney, August the 7th, 2025. Later that day, the City Attorney, in an email to Ms. Hudson and the full council, confirmed that the Mayor's August 6th directive was legally appropriate and fully aligned with city policy, procedure, and applicable employment laws. Compliance was necessary to protect employee rights, prevent retaliation, and reduce legal liability. The EEO matter would be discussed in the August 11th, 2025 executive session and would not be addressed publicly. Number 4, public disclosure in violation of confidentiality was on August the 9th, 2025. Despite these clear directives on August the 9th, 2025, Ms. Hudson posted an article on the public forum fairburnforward.com titled, "When Transparency is Replaced with Silencing Tactics." This post made direct public reference to the pending EEO complaint information she had been specifically instructed was confidential and to be discussed solely in executive session. Applicable ordinance violations. Number 1, Section 2-35C3 prohibits disclosure of confidential information acquired by virtue of official position. Section 2-35C11 prohibits disclosure of confidential information without approval of the governing body, including A, information not subject to public disclosure under Georgia law, and/or B, information obtained in a duly closed meeting under Georgia's Open Meetings Act. Number 4, harm and risk to the city. Ms. Hudson's actions have compromised the confidentiality of a pending personnel matter. She disregarded multiple lawful directives from the mayor and city attorney, created potential legal exposure and liability for the city, undermined the rights of a city employee under federal, state, and municipal law. The relief requested, I submit this complaint to prevent further harassment of any city employee or official, protect the city from further legal and financial liability arising from unauthorized disclosures, request that the matter be investigated in accordance with the city's ethics procedures and that appropriate corrective or disciplinary action be taken as provided under city's Code of Ordinance. Submitted this 11th day of August 2025, Mario B. Avery, Mayor of the City of Fairburn. I'm going to read the post. When Transparency is Replaced with Silencing Tactics by Councilwoman Samantha L. Hudson. On August the 6th, 2025, I received a letter from Mayor Mario Avery notifying me of an equal employment opportunity EEO complaint filed by the city clerk, Brenda James. The complaint included allegations such as constant harassment through emails, false and defamatory statements to the Georgia Attorney General, and on social media, age-based remarks, and creating a hostile work environment. The letter went further. It issued me a cease and desist directive ordering that I have no direct contact with the city clerk in any form, including email, phone, text, in-person conversation, or even social media references. All my communications to the clerk's office must now be routed through the mayor himself. Here's the problem. Under the Georgia law, OCGA 36-35-3, and the city charter, I am an elected official, not a city employee. The mayor's letter even admits that elected officials are expressly excluded from the city's personnel policy coverage, yet he still used that policy as the justification for restricting my access to the clerk, a key part of my ability to do legislative work for you, the residents. This isn't about protecting employees. It's about controlling information and isolating an elected representative from the people and processes I'm sworn in to serve. It's also important to note that I have documented history of raising concerns about government transparency, ethics, and legal compliance. Restricting my access to information and placing all my communication under the mayor's control raises serious concerns about retaliation under OCGA 45-1-4, Georgia Whistleblower Act. The mayor's letter also warns that breaking his directive could lead to censure, reprimand, ethics complaints, or other lawful remedies. In plain language, comply or be punished. Why should this matter to you? Because this is not just about me. If a sitting council member can be silenced, isolated, and stripped of direct access to city staff without due process, anyone who challenges the status quo could be next, whether they are an elected official, a city employee, or a resident speaking out. Government works best when it's open, transparent, and accountable. This kind of conduct sends the opposite message. Speak up and we will find a way to silence you. I will continue to carry out my duties under the law, represent the interest of the residents of Fairburn, and fight for transparency, both inside and outside the council chambers. Your voice matters. If you care about fairness, due process, and open government, now is the time to pay attention. Councilwoman Samantha Hudson.
Any discussion?
I have a question of clarity for the attorneys. Go back to the first page under number 2. This is, I just need clarification on this.
First page, number 2, summary of events
No, refusal, I'm sorry,
of the complaint.
on the complaint, yes. First page of the complaint, tab 2, number 2. Where it states in a rebuttal letter sent at 12:16 p.m. on August 7, 2025, Ms. Hudson wrote, and it states what she wrote, but should we have in part there? Because that's not all of what was written. Do we need to put in part for clarity?
Well, we can amend the complaint. The complaint is the complaint. We can make reference to it, and you can consider that in your deliberations.
Okay.
You can read it all.
But
Did you say you can read it into the record?
I think we've have it because it was sent to, I think all of you were on the email too, if y'all have it. So if you wanted to read the entire thing into the,
I'm just, I mean, in reference to legality and clarity is what I'm thinking that we're, you know. If you all think that's fine, the way it is, then that's fine with me.
I mean, I think the record, the complaint is the complaint, and I think we have to stick with what's in the complaint. Now you do know that at some point this evening, you're going to deliberate, and one of the items that you're going to deliberate is whether or not you should subpoena evidence, whether or not you should subpoena witnesses. That's an option. But the complaint is the complaint, and it needs to be read into the record as it is.
I understand that, attorney, but what I'm saying here is that this should be identified as in part, not the whole thing that was stated. That's what I'm just saying.
No, I understand. I think the record can reflect that. I will tell you also, however, the rules allow you at Section 235 to consider your personal knowledge in this process. The emails were delivered to each of you. We know they're not here, but you can consider your personal knowledge. And also, there's the opportunity at some point to subpoena additional witnesses' evidence, and that would be something that also could be subpoenaed.
I don't quite think you understand what I'm saying. Should it be Ms. Hudson wrote in part, and then this stated?
And I think
Nope, no, that's not, it shouldn't be. The words in part should be identified here as, okay,
I think that could be your finding and your determination.
okay.
But the complaint is the complaint is the complaint. We don't get to amend the complaint.
Okay,
And so, but you could, in your deliberations, you could reflect that, and you also can take into consideration your personal knowledge of what you received. Like, you know you received a full document,
Yeah.
right, or a fuller email.
Yeah,
But I'm sorry, we just can't.
okay.
You
I
can't
mean, I
avoid-
understand what we can do in deliberations. I'm just trying to make sure that this is listed correctly from just an understanding of this. But if you say it's not,
I'm saying
it's
it,
fine.
and when, I mean, that could be part of your finding.
May I? Remember, this is the statement from Mayor Avery, right? These are his words. And so we can't interject into his statement, but you bring up a very valid point, and I think that should be additional information that should be requested and reviewed during our deliberation.
Yes, yes, and I think Whitmore had a, Council Member Whitmore had a concern as well.
I'm just going to ask a question. I see here, and my colleague just identified the fact that this ethics complaint was generated from Mayor Avery,
Yes,
all right? And I was just looking, and I didn't see anything in the package that I received. So I understand there's a EOO complaint, right? But I don't see that in here, so I'm not sure. We're talking about, it's going to be a couple of things that we're going to be talking about in deliberation, all right? You have what the mayor put together here, but I'm looking for the additional information with the EOO complaint that was filed by Ms. Brenda James. So we don't, from what I recall from reading my emails, there's about 4 charges on there, age and a couple of other things, but I don't see any documentation in this package that was left up on the dais for us to review, discuss, and then go into executive session about.
yes.
That's correct, Councilman. What we did not want to do, you all have received the EEO, you have seen the EEO in other instances. And what we did not want to do in tonight, and I'm not sure what made the mayor not attach it, I don't know, but we did not put it in here for public discussion because we will be doing, again, what the complainant alleges was done, that the EEO complaint was made public outside of council's decision-making. And so because you are able to take into account what you know already, your personal knowledge about this matter, you can take into consideration the fact that an EEO complaint was filed, and you all know what the contents are, and you all were copied on the emails concerning the cease and desist and the responses by both the city attorney and Councilwoman Hudson.
All right.
So we can talk about that more in your deliberations, I think.
Yeah, I understand that, but I think, and I'm being very careful here, because of the executive session that we just held, whereas there were some very skewed comments by the attorney that did the investigation, which the mayor stated they were going to have that attorney come back because I think there was some confusion in the statements that he allegedly said that was not factual, and I'm trying to be very careful with that.
Yeah, I'm sorry, you're conflating issues. When you say he, the outside investigation was not done by a he, it was a female, and it had nothing to do with.
Well, I apologize. I didn't mean to allude it was he. When I said he, I'm speaking of Mayor Avery.
Okay.
I was not speaking of the female attorney. Mayor Avery stated for the record, that attorney needs to come back because of things that was in that report appeared to be.
And that has nothing to do with what we're here. That's totally irrelevant to these proceedings?
I thought that that was also addressed in that. Am I correct or am I wrong?
Absolutely not.
No,
And I stand to be corrected. I retract my statement.
yes, sir. That's a wholly different issue.
I had so much coming through the email, and I tell you, just reading through it, I got stuff going on, and I'm trying to figure out
It's understandable.
what's left, what's right, and who's on first.
But not germane to these proceedings. It's a
Thank you.
matter of record.
Thank you for the clarification.
Okay. Is that everything? Okay. Executive session for deliberation of ethics complaint recommendations. Is there a motion to convene to executive session to deliberate?
So moved.
Second.
Discussion?
So all in favor, say aye.
Aye.
Opposed?
Parliamentary procedure?
Call for the question.
Yeah.
I
We
said-
we had discussion, and you,
I'm asking for the parliamentarian.
What's your point?
There was a motion, and there was a second, and there was a vote, and I said discussion in reference to something else that I wanted to talk about. I'm not asking my colleague to give me legal interpretation. That's what your job is. So once I said that, I know two of the attorneys looked up at me, and they were waiting for some sort of procedural whatever, but it didn't come from from your side of the house. So all I'm saying is that, yes, they put a motion on the floor, it was second. Before the vote, I said discussion, even though they went forward with the vote. So procedurally speaking, I didn't get an opportunity to have that discussion of the additional item I wanted to ask about.
Yes, so the motion was made as second, and discussion is proper before the call for the vote. And just for clarification, Madam Clerk, can you read the motion that was made?
The motion was made to convene into executive session to deliberate.
Thank you. And then there was a second made by whom?
The second was made by Hattie Portis Jones.
And Mayor Pro Tem, it is appropriate to have discussion at this time.
Call for discussion.
Okay. So I guess we convene into
No, there's Whitmore.
call for
Call for
discussion.
discussion.
I'm sorry.
On the motion,
Yeah.
yes.
Call for discussion.
Just for clarity, Attorney, I'm Councilman Whitmore, not just Whitmore. I address you as attorney, sir, so I think that's very disrespectful. So I would ask you to call me by my title, not just my last name.
Absolutely.
Thank you.
Councilman Whitmore.
I appreciate that. Thank you much. So my question to the attorney, okay, I noticed that the complainant is the mayor, and I think that leans towards not seeing anything from the clerk. So my question is, we're proceeding, moving forward on a complaint, an ethics complaint from the mayor without any documentation from the clerk. I think you see where I'm going with this. I'm just trying to make sure that as we move forward, we're dotting i's and crossing t's. Now, if I'm missing something, that's why I asked for discussion.
I think we can all recognize that there is a conflict of interest with respect to the clerk being involved in the process of getting the investigative committee convened, sending the complaint out to the relevant parties. And so the deputy clerk is the next choice, and then logical choice and legal secondary individual to take place when there is a conflict. The underlying complaint that was filed, the ethics complaint, involves an issue, a personnel issue concerning the city clerk. The city clerk is the subject of the EEO complaint. She's the subject of the complaint that was filed by the mayor, the subject of discussions by Ms. Councilwoman Hudson. And so you all recall that the notarized complaint that the mayor sent was sent to you all by the deputy clerk, your duly authorized deputy clerk. And under the charter, she steps in when the clerk cannot. So all of the processes have been, there are conflicts of interest, and so all of the processes have been done in order to keep the process from being tainted by someone who has a conflict of interest. And that's why you have the deputy clerk here handling this matter.
Madam Attorney?
Yes.
That was not my question. My question was, I had the official complaint that the mayor put together outlining the ethics code and Georgia's code and everything else. My comment was, the mayor filled out the ethics complaint. I don't see anything from the clerk. I know that the deputy clerk is fulfilling the job as the official scriber and keeping accurate notes. That has nothing to do with the question that I asked. And I repeat, the question that I asked was, in the documentations that was left for review and to go into executive session for deliberation, I have no comment from the clerk, in this case, Ms. James.
Okay, thank you. Thank you for your clarification. I'm sorry if I misunderstood.
No problem, that's why we're talking.
But at this stage, this is a stage where you all are making a preliminary determination as to whether the complaint as written and received and notarized meets the bar for either you all deciding to do a motion, come out of executive session and do a motion for subpoenas and other witnesses to come forth to give you additional information before you can make that decision, or if there's sufficient information that you can just forward it to the ethics board for a hearing, or dismiss it. And so in your previous ethics complaint proceedings, you never had the person coming who was tangentially involved coming to speak to you all at this stage of the proceeding. So this is the preliminary stage, and if I'm missing it again, why don't you tell me what you think the clerk needs to have before you to make your decision
I
tonight?
wasn't asking that Ms. James be here physically.
Okay.
What is her official complaint? The mayor identified 4 charges, okay? It's not mentioned in this complaint. So where is the information from the actual complainant? That's my question. Now, I'm going to say this. I'm a novice. I'm not an attorney.
Okay.
I don't do this for a living.
You don't play one on TV, right?
I don't play it on TV, exactly.
So here's what I know. Here's what I'll tell you. And I thought I answered that, so I must not have done a good job. So let me restate what I believe to be its appropriate answer. The complainant in this matter is not Brenda James. It is Mayor Mario Avery. He has filed a complaint that there was an improper divulgence of confidential information pertaining to an underlying EEO complaint filed by Ms. James, the city clerk. And so while that issue, of which you all have seen it. You all have seen the complaint. You know from your personal knowledge what it entails. And so this complaint is about the disclosure of that information that you already know about. And while it may become relevant, the contents of it as we move forward, your charge tonight is to make a preliminary finding as to, based on your personal knowledge and what's alleged in the complaint, as to whether or not there's sufficient information before you that can allow you to do one of the 3 things. I hope I asked it. Maybe 3rd time's a charm, Councilman? No? Does that do it?
You covered what I was looking for, but let me state for the record.
Yes, sir.
Okay, is that when I come up here to sit in this type of forum, I'm looking for everything, so I don't have to ask for anything. Okay.
Okay.
So in that context, that's why I asked the question, because even when we go into deliberations, I may have a question about conversations that took place between the two, the clerk and the mayor. I don't know if it has or hasn't, but what I'm saying is, without her statement, that would, okay, so I'm reading into this just like everybody else is, just like you are. All right, the mayor put out an email to our colleague, okay? And then there were other correspondence that went back and forth, all right, which led to us being here today, correct?
I'm assuming, I think what I understand from the complaint, I'm not assuming a lot of things. I know from the complaint that there was some disclosures on the website, on the internet, about this confidential EEO personnel proceeding.
Right.
And that, to me, may have, in my mind, that's what spurred this, not the actual discourse that occurred before that disclosure was made.
Well, that's what I'm talking about, everything that's in Mayor Avery's letter here.
Yes, sir.
Okay, so I'm not talking about other disclosures right now, but my question is, and I'll repeat it again, I understand why we're here. I have the formal complaint from the mayor dated on, actually, there is no date.
It's dated August the 11th, 2025, notarized per
Yeah,
policy.
on the second page, August 11th, 2025, yes, sir.
Mayor is listed as the complainant, Hudson as the respondent.
Right.
Duly notarized in compliance with the city ordinance, section 235.
Right. And then what I was looking for also, just like you have here, you added the post, when transparency is replaced with silencing tactics, okay? And then when I go on to the next, deal with whatever that's dealing with, then I go to section 3, then you have the administration dealing with Article 1, going so on and so forth. But you had nothing in there from the person that, the reason why the mayor actually put the complaint together. I didn't see any statement from Ms. James. That was my whole context and deliberation and asking for discussion.
Yes,
Where was that? If we had anything or anything else, and I think you answered it by saying, if we need additional information, we can either call witnesses and so on and so forth. So I think you answered it in that respect, but I just want to make it clear because it was ambiguous.
Yes, I can understand. So yes, so at this stage, you all don't take witnesses right now. So you're going to go and deliberate when you and your colleagues are deliberating on whether the complaint as filed is sufficient in your minds, using what was filed and what's in your personal knowledge. You can then come back out and make whatever determination or recommendation from there.
I'm good. My last comment, because I think when it happened here on this dais tonight, it's not the first time it happened, but it happened tonight, as soon as the question is asked or a motion is made and you get a second and there's a question, the history is someone will say, call for the question, to stop all conversation. And I know you immediately looked up, and so did your colleague, Madam Attorney, to your right, knowing that procedurally that was wrong, but I just want to make sure that moving forward, that we're conscious of that, because this is not the first time that that has happened on this dais.
Well, we actually all looked up because you had a point of order, and we've addressed it. So if you don't have anything else, can we move forward?
We can, but you didn't address it, sir. I had to address it. So you're the parliamentarian.
Are you satisfied?
But can I finish?
Please, Council
Thank you.
Member Whitmore, please finish.
Thank you. I just put something on the table to be acutely aware of because of the practice. That's all I did. As the parliamentarian, you're the one that interprets the flow and the process. But that was to cut the process off deliberately. And that's why I'm making the statement. And now I concede.
Thank you.
Mr. Mayor Pro Tem, if there is no other discussion, you can move to call for the vote on the motion to enter into executive session for the purpose of deliberations only.
Okay, is there a motion to reconvene, oh, I'm sorry, is there a motion to reconvene? Gotta work, can't even talk. Is there a motion to convene into executive session to deliberate? And I think that's what we
I think, yes, sir. That motion has been made and properly seconded. You've had the discussion, and now you can just call for the vote. All in favor?
All in favor?
Aye.
Aye.
Opposed?
So motion carries, and we will now enter into executive session for deliberation.
Is there a motion for the recommendation on ethics complaint 2025-04?
I'm sorry,
I'm sorry.
Mayor Pro Tem, but you need to do a motion to reconvene
Oh,
into public session.
okay. Yes. Is there a motion to reconvene into public session?
So moved.
Second.
All in favor, say aye.
Aye.
Opposed? Okay. Motion carries. Is there a motion to approve the executive session affidavit?
So move.
Second.
All in favor, say aye.
Aye.
Is there a motion for a recommendation on ethics complaint 2025-04, Avery versus Hudson? All in favor?
Madam Clerk, may you read the motion, please?
Okay, is there a motion for a recommendation on ethics complaint 2025-04, Avery versus Hudson?
Madam Clerk, read the motion.
All in favor, say aye.
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 Opposed?
I make a motion.
I'll make a motion.
Second.
Sorry.
And as a point of clarification, did we say section 235H11? We say, okay, just want to be clear.
Hattie made the motion.
Councilwoman Davis.
Okay,
Second. Yes.
second? Okay, got it. All in favor, say aye.
Aye.
Nay. Opposed, nay. Motion carried.
Motion, y'all ready to get out of here, right?
Yes,
I
sir.
make a motion to adjourn the investigative committee hearing.
Second.
So moved. Second.
Second.
Aye.
All in favor, aye.
Aye.